Any mentioning, let me mentioning to you. Yes, sir.
Lordship, may I proceed? Lordship, I beg to mention item number 23. Lordship, and first of all, for the day, my senior is suffering from fever, and I have taken consent of other side.
Yes, next.
May I please your lordship? My lord, with the consent of the other side, I beg to mention item number 9, my lord. This may come after 10 days, my lord.
Yes.
My lord, I beg to mention item number 11, my lord. In this case, my lord, they are supposed to file an affidavit today, their third copy, my lord. So matter may be listed after 1 week. Item 11. I've taken the consent there, lord.
You are filing affidavit.
They are filing affidavit today.
They are filing it.
Yes, they are third copy.
3 weeks.
Please, your lordship. Lord, I beg to mention item number 17 and 18 of today's daily list, my lord. So here, Mr. H.K. Das appears on behalf of the Honorable High Court, who was unable to appear today owing to some personal difficulty. May I pray that the matter be taken up any day in the next week?
31st. Other matters we have kept on 31st.
Yes.
You ask Mr. Das, we would like to know the current status because the LRS filed the affidavit,
Yes, lordship.
but we want further detail.
Yes, lordship.
Huh?
Matter may be taken up in the next week.
31st. Other matters are kept on
Yes, yes,
31st.
yes, lordship. I'm obliged. May I please, your lordship? I beg to mention item number 2 of today's list.
What have you done?
We need to file an affidavit, your lordship. So for that, we require 1 more week time.
No way could be found out.
Your lordship, petitioner's claim is totally different, as they have purchased the property much before the date of the mortgage.
Yes.
So that is why the
No, but ultimately it was mortgaged by the husband, isn't it?
yes, your lordship.
It was mortgaged by the husband. It was mortgaged by the husband.
Yes, your lordship. It
Hmm.
was mortgaged by the great petitioners, your lordship.
Anyway,
Immediately.
we want time. Next
No,
week.
no, lordship. We have never mortgaged it.
We'll hear you.
I'm for it.
The mortgage was created by the Rahul, the landowner, and they have purchased the property much before the date of the mortgage.
Then it is your mistake, not his mistake.
Yes, your lord.
You should have given a thought on the title of the land.
Yes, your lord.
That is why we are saying find out a way out. Otherwise, bank will be at loss unnecessarily.
Yes, sir.
Next. Come next week.
Maybe Lordship, I beg to mention item number 3 from today's daily list, Lordship.
Yes.
Lordship, we need to take some certain instructions from the department, so we need 2 weeks time, Lordship.
Next.
May it please, my lord. I pray for the listing of a writ petition which is filed challenging the virus of Rule 5 of Medical Colleges of Assam admission into postgraduate rules 2021, my lord.
What is your request, sir?
My lord, the second round of counseling will be over on 20th of this month. I pray for a listing of the matter thereafter, my lord, subject to lordship's convenience. 28th or soon after that date, my lord.
We'll give some date. Give some date. Next.
I'm obliged, my lord.
Yeah, have your lordship permission to
Yes,
mention
sir.
a matter, my lord. The matter was listed before court 8 as item 16.
It was
But the court 8 item 16.
Huh.
But the court, because I don't appear, my lord, so the court is directed, release the matter and directed to be listed before any other court. There's some urgency in the matter. If your lordship could consider.
but it will have to be brought on administrative side before me.
Oh, weekly, okay.
You can give details to my court master.
Deeply
Ask your AOR to give those details.
Deeply applied.
Chalo, follow.
WPC 5248 of 2020, WPC 28 of 2020, PIL 83 of 2021, and WPC 1208 of 2022 are hereby dismissed. As far as the alternative prayer prayed for in WPC 5169 of 2020 is concerned, same stands exhausted as the exemption is granted by the state government. In the light of the view taken by this court, the APSC is at liberty to declare the final results of the Combined Competitive Mains Examination 2020, written and interview, and complete the recruitment process as prayed for in IA Civil 1572 of 2022. Interlocutory application stands allowed accordingly. In the facts of this case, parties to bear their own cost.
Thank you.
नहीं करेंगे चेंबर में तो करें हाँ ठीक करते हैं तो खोल के जाना अपलोड करते हैं कंडीशन करते ठीक तो फोटो for fill out to sign it next pull out
May I please your lordship? Lordship, this restriction criminal has been preferred against the illegal detention of the petitioner.
will issue notice
Lordship,
notice Ms. Bhattacharya is for so and so
Lordship, I am praying a shorter notice because by effects of the time, I have more than 1 year lordship now illegally.
it will be one week or maximum 10 days next
This matter has virtually become infructuous. Why? Tender was floated by the state of Mizoram for running a pharmacy, running a pharmacy, Mizoram Medical College. This was for 2019 to 2021. So which we have given to a private party by interference of the court, the appellant, one of the appellant running the pharmacy. We are at heavy loss, my lord. Because 2019 to
new tender
2021.
process have been initiated.
My lord, no, my lord, there is a stay order operating.
This is the whole problem.
I was just thinking aloud. Because if you see the notice,
In any case, my lord, the term has come to an end.
that is why now it has become academic.
So it
Yes,
can be, my lord,
academic.
disposed of, giving liberty to the authority to issue press tender.
And wishing you good luck to compete
No, my lord, I am also, I am representing the director.
He is independent
I am
director.
representing one of the officers.
for a change. That's why I was wondering why you have come on this side, but I was not knowing that you are appearing for.
Lordship, may I pray for taking up the matter after some time? Lordship, Senior Counsel Mr. Devajit Seke will be appearing. Lordship, he is on his way.
He should be here.
Lordship, he is on his way. Lordship, let it be after some time. Lordship.
We know now physically we will find it difficult to be here in Gauhati only, but we can't help him in the court. He might go to any country also now. Or neighbor country series is
We are
coming
running
up.
at a
I
very
read in
huge,
newspaper.
we are running at a very huge loss, my lord. Because 6,000 only they are paying. And as per the court's order, 60,000 to be paid.
No, that we are not going into.
No, that's why I'm saying, my lord, it will be academic only. The period is over. 2019 to 2021. Today we are 22.
Now Mr. Sakia is not there. What do we do?
Well, your lordship will take after some time, my lord.
Next. Next. Special notice.
As per office note dated, Lordship, 19/10/20, the service is awaited from respondent.
Service is awaited. And await service, give the date.
May I want to let the LCR maybe call for.
Next, LCR be called for. First to reach this court on or before 14th of November. Extend to 15th November. Await service.
Obliged.
Next.
Wait, please, Your Lordship. Lordship agrees by the order dated 25/2/2021. This writ appeal has been proposed. My lord. The order stands at page 110 to 115. And there were areas of salary with regard to revision of pay scale that was sought for.
No, but you have been given benefit by the learned single judge.
My lords, partial benefits, I'll say.
Then
The benefits that were given was with regard to the pay scale of 98, but the pay scale of 2006 was in effect. So our contentions were that 2006 pay scale should be granted to the petitioners herein, along with other benefits that will follow. That is the BRS scheme, that is 45 days of computation of the yearly benefits of the basic pay scale, but only 15 days were given. So unto bringing all those contentions, we have preferred this appeal. My lord.
notice. Bhattacharya ji waive for
1 to 5 Lordship, I'll pay.
1 to 5. You waive for
7 and 8.
so no formal notice would be necessary. Next. Keep it after 4 weeks. Next.
This appeal has been referred before Lordship against the impugned order of the learned single judge, whereby reconnection of the premises of the present appellant has been rejected on by impugned order dated 28 July.
There are findings by the learned single judge, there is
Yes, ma'am.
suppression of fact.
Lordship will find that operative portion of the impugned order
No, para
117,
14 of the judgment.
page 117.
Please read para 14 of the
Yes,
judgment.
I'm
Bhaiya,
coming on that.
This is not working properly. What is coming properly?
May I read out?
Am I audible?
Yes.
After पास में कितना लगा तो मुंह में डाल दूँ मुंह के पास तो रखा है यार. I think there is some difficulty with this. It has happened today only. Get it checked. You turn to para 14 of the judgment.
Yes.
Please read.
May I read out, ma'am? However, in the instant case, it appears that facts which are very much relevant to the issue have been suppressed in the writ petition. The petitioner on her own volition had instituted miscase number so and so before the appropriate court for restoration of electricity, which was dismissed by an inter-party order dated 11/5/17. The said order was also the subject matter of an appeal in miscase appeal number 4/17, which however was dismissed due to non-persecution and for not taking a step. Instead of continuing her challenge initiated in filing of the miscase number so and so, the petitioner had shifted by filing the present writ petition before this court, that too by suppressing material facts that known to her. The explanation that the petitioner belongs to the weaker section of the society is not at all acceptable in view of the nature of the suppression made, and also the fact that the petitioner had the means to file a writ petition in the High Court and at the same time cannot continue with the appeal preferred by her in the appellate court.
So, Mr. Paul,
Yes.
those days of two horses buggies have gone since 1947.
My lord.
In British era, there were buggies of two horses. Buggy, horse-drawn canal, carriage.
Wrong here in this, my lord. Actual fact is that
What is he saying? He doesn't understand.
I am unable to understand remark of your
That is
lordship.
our misfortune. You leave it. There was suppression of material fact. This is a
No.
finding of fact. Why should we interfere?
That's why I would like to submit before your lordship. Actually, there is no material suppression of facts so far as.
Did you file appeal or not? Did you
Let-
approach the authorities or not?
Let me explain the previous
No,
facts of
but
the case.
have you disclosed it before the learned single judge in the petition?
My lord,
The answer is no to it.
no, the present appellant is a very illiterate lady.
That is
And what
neither
was
here
the
nor
proceeding
there.
before the,
That you argued, that is considered. That is neither here nor there. She had not appeared as party in person here.
no,
Who appeared?
I am appearing.
Then was it not your duty as a law officer to tell the court this?
Yes, I am trying to
Then-
submit before a lordship the
These are
actual
all
fact.
lame excuses, Mr. Paul. She was assisted by an expert like you. Don't take shelter that she is weaker section or
Let- let- let-
those
let
days
me-
have now
let-
gone.
Lordship,
We are in the Amrit Mahotsav here.
let me try to point out the original fact. Actually, at the time of filing of the writ petition, these documents, those are submitted by the, as affidavit in opposition in the writ court,
Naturally,
was not in the hands of the present petitioner.
that is why it is suppression.
And now what is the facts?
Mr. Pathak, who appeared in the proceedings before the appellate court and all? Any advocate?
I think counsel was probably different for the petitioner.
No, but advocate appeared.
Advocate appeared.
Then
Advocate appeared. Those were inter-party proceedings contested and disposed of by the learned judge.
Now, my lordship, I am trying to.
who appeared before the authority?
Mr. R.K. Pathak, no. Let me.
Then?
Bhuya.
He is an advocate. Where is the question of illiteracy?
Sri R.K. Bhuya.
Where is
Appear-
the question of illiteracy? These are all lame excuses.
No. Actual fact is that there was a civil dispute between the
Hey, Mr.
aspirant number
Paul.
4 and the appellant.
Mr. Paul,
Yes.
we don't want her to pay the cost. That much we can interfere. Otherwise, on merits, we are not ready to, we'll hear you because we are duty bound to hear you. Otherwise, we are not inclined. Let us be very fair. You can't write two horses at a time.
Actual fact, I am trying to point out before lordship at this stage that she was a very illiterate lady
I
and cool
think
lady.
you want us to.
What was
enhance
the
cost.
business dealt with by her lawyer in the appellate, in the trial court, that was beyond her knowledge. And she was not equipped with all the informations what was going on in the trial court. So as a result, all the documents was not possessed with her before filing the writ petition. So that was not intimated. But that fact came up before the learned writ court for argument. But what happened in that case, my lord, only her electricity was denied by the learned trial court, that she doesn't occupy the premises for which she has applied for. A dispute and contradiction between
That
ward
is
number
what-
3 and
that is
4.
what Mr. It was examined by the authorities and on examination and appreciation of the evidence which was led by the petitioner appellant, the appeal also came to be rejected.
No, that was as a misappeal, and it was not rejected. It was dismissed for default. So far as Supreme
Whatever
Court
it may
laws are concerned, my lord, I would like to rely on judgment of the Honorable Appeals Court. Dismissal for default doesn't mean that it attains any finality. And moreover, the
Anything else?
issue of electricity has come up in the title sheet as a collateral issue. It was not a.
At the most, we can provide that you may apply again and it may be considered by the board. Because it's a question of electricity, we may say so.
Yes.
Otherwise, we are not ready to say that the order is wrong.
No, I am not submitting that order is wrong. Only
You may not, we will.
only delving into some technicalities. Learned single judge has replied me. Only dwell some technicalities.
What you term as technicality is not technicality. It is a matter of fact. Suppression is a grave.
But this appellant doesn't know what is material or what is
Mr.
immaterial.
Paul, please don't take us to that. You are arguing in 2022. She was represented by an advocate. We can understand that a poor lady comes as a
In
party.
the
in
trial
person.
court, I was not represented.
But there are many advocates in Gauhati. You are not the only advocate.
Yes.
So don't take it upon you. The question is, we are ready to interfere. Cost even 10,000, she may not be able to pay.
Very true, maid servant.
Therefore, for that you need not even argue. But on merits, we are not ready to interfere. We may only say that it will be open for you to apply again and it may be considered by the power company. That much we can provide. Because it
If
is
your lordship would
electricity.
direct me to giving opportunity to apply again for the
That is,
premises,
that we will grant you.
that might be, madam.
Hold Mr. K. Paul for the appellant. And Mr. Pathak. You are on advance copy, Mr. Pathak?
I am for response numbers 1, 2, and 3. Your Lord.
Mr. K.P. Pathak. For response number 1, 2, and 3. Feeling aggrieved and dissatisfied by the judgment and order dated 307/2022 passed by learned single judge in which petition civil number 5122 of 2021. The original petitioner appellant has preferred his intra-court appeal. Having heard the learned counsels appearing for the parties, it appear and considering the factual matters arising in this appeal, it is the case of the appellant that she is residing in a Kacha house in ward number 3 of Rangia town with her family members since last 20 years. It appears that there is a dispute between respondent number 4 and the appellant, and the title suit being title suit number 2 of 2015 is pending before the court of Municipal Rangia. Was filed in so-and-so case, which came to be decreed in favor of respondent number 4 on 5/1/2008, against which an appeal has been preferred by the appellant, being title appeal number 1 of 2018, and the state appeal is pending. The proceedings initiated were initiated by the respondent number 4 Electricity Authority by issuance of Toko's notice dated 31/3/2017, asking the appellant to show cause why electricity should not be disconnected. The record further indicates that the appellant herein approached the competent court by way of filing miscellaneous case number 34 of 2017 for restoration of electricity, which came to be dismissed on 11/5/2017. The record further indicates that an appeal came to be filed against the state order, being miscellaneous appeal number 4 of 2017, which was dismissed for want of non-prosecution. Full stop. It is an admitted position that suppressing such facts, the appellant approached this court by way of a writ petition under Article 226 of the Constitution of India, and inter alia prayed for almost similar relief of restoring providing electricity. The learned single judge, taking serious note of the fact that the appellant is guilty of suppression of material facts, dismissed the petition. Though a lame excuse has been even put forward by the appellant before us that he is illiterate, does not hold good in view of the fact that before the appropriate court, the appellant was represented by an advocate. In light of the aforesaid, therefore, we are in total agreement with the observations made by the learned single judge, and more particularly, the observations as regards suppression made by the learned single judge in para 14 of the order impugned before us. However, even while rejecting the appeal on merit, we hereby modify the order of cost of rupees 10,000 and we relieve the, and the order of cost is cost, no cost be imposed upon the appellant. It is however clarified that the same such order is passed only on humanitarian grounds, considering the financial position of the appellant as submitted before us by Mr. P. Paul, learned counsel appearing for the appellant. A. Paul. Paragraph. At this juncture, Mr. Paul, learned counsel appearing, A. Paul, learned counsel appearing for the appellant submitted that the appellant be permitted to approach the respondent electricity company for a fresh connect. The appellant is at liberty to do so, and if any such application is filed, the same shall be examined by the electricity company in accordance with law.
My lord, one thing I would like to request that so far as electricity law, many documents have to be furnished to the authority. Because as I am disputing the premises, so I may not be possessed with the relevant documents as required by them. So that may be one.
Next.
Obliged.
May it please your lordship. In this case, the impugned, I have challenged the order of the learned single judge dated 14/9/2021, passed in WPC 4541 of 2021.
Hold so notice.
Okay.
Notice. Ms. So you are for the revenue department?
Yes, your lordship, respond number 1 and 2.
He waived for 1 and 2. Take justice service for others. All are government, but they are not represented today. Therefore, we are saying, of them, it is this poor only. Director. Mr. Bora, would you help us?
3, 4, 5 minutes.
Then nobody is left. Right, R.K. Bora. Hence, no formal notice would be necessary. Next.
Bless you.
Obliged.
Before my learned friend starts, my lord, the writ appeal is defective, my lord. They have not annexed our affidavit and all, my lord. How do I defend today, my lord? The papers are not.
You can file a paper book, Mr. Chaudhary.
My lord,
you can file a paper book.
Yes.
My
Our
lord, there are,
affidavit is not annexed, and we'd like to rely upon some documents, my.
my lord, there are multi documents. There
No,
are
no,
eight
this is as
pleadings,
per
my
the
lord.
requirement of the Gauhati High Court rules.
That's
This is
right,
not
my lord.
submission of me, my lord. The Gauhati High Court rule says whatever are the pleadings which are before the learned single judge, at least the affidavit, main affidavit, my lord, that is not there.
Mr. Chaudhary, therefore, I invited you that you file the affidavit, the paper book. We'll take it up.
Yes.
Sometime. Even otherwise, Mr. Chaudhary, I was just inquiring because I was not actually knowing. So I had to talk with my brother. I would disclose that also. I just wanted to know that settlement here in Assam takes how long? Then the period which I was told, I was astonished.
And they have already enjoyed for 20 years, my lord.
No, in my state also, settlement takes a long period.
Yes.
But I may tell you, sometimes the period which brother has indicated is much less than what we have faced in Gujarat. Because that here you are lucky that killing acts are not that stringent. That settlement is straight. There the authorities have to take that also into consideration.
Correct. So, my lord, they will file the press copies, my lord.
You file or he file.
Okay, then let it come upon some other day, we'll file it, my lord.
That you have to settle over a cup of tea or coffee.
Okay.
Lal chai in the bar room.
On 26th, my lord.
No, 26th. This 26th. No.
Any other day, my lord.
Some other day.
My lord.
They will be at the earliest, my lord.
Yes, it will be earliest, but 26th is difficult.
Okay.
I know that. My brother tells me something, Mr. Chaudhary, which I was not knowing.
That you can check up with Mr. Chaudhary whether any amendment has been incorporated, not to our knowledge, because he is the author of the rules. And he is the compiler.
I have compiled it, my lord. I have not uploaded it.
Next.
Yes. Item 13. Mr. Hussain,
Yes, my lord.
tell me.
My lord, here is a case, my lord, the husband of the petitioner, my lord, two
Where is
persons.
Dinath? Oraji? Where is Mr. Dinath? Ah, he has come. Hey, he has come, yes. There are sometimes good reasons to stand outside the courtroom. Don't know about Mr. Nath, but we know you are a busy counsel. What is the position here?
Well, the status report has come, but the investigation is not complete. The IO has again requested me for some time.
How much time?
Lordship, he has prayed that 1 month time may be given to him. Lord. Lordship may give you 3 weeks time.
3 weeks?
Lord.
Out of question, what are your officers doing?
Look.
1 week at the most. Or 2 weeks at the most. Otherwise, we'll ask your DIG to investigate. Your police inspector cannot decide the timetable. We have already granted him much time.
That's true. One DSP level officer is investigating. One DSP is investigating.
Therefore, we are saying DIG. We are conscious about the designation SP and then comes the DIG. So you tell him that it should be over. At the request of Mr. Dinath, adjourn to 21st. And if he is not in a position to complete the investigation, he has to be here on 21st of November. So that in his presence, we'll ask him that who is the next above him. Convey our feelings to the concerned officer. He just can't sit tight over the investigation.
Definitely, I'll contact.
Next.
May I please your lordship? Lordship, as per the office note dated 1/10/2022, the service
Service is
report
awaited.
awaited lordship. What happened here, lordship? The respondent number 7, lordship. He was serving as the MLA at that time, lordship. He is the ex-MLA now, lordship. And the main grievance is, lordship, against the order of the BEO, Block Elementary Education Officer and DEO. So, lordship, if this court permits.
Being MLA is not a service, so don't say that he was serving as an MLA.
He's not in serving.
MLA is not a service.
Lordship, he's
It's a
not serving now.
public office. He is not in office, you should say so. Await notice.
Obliged,
After 15 days. Next. इसमें क्या था? इधर एक छोटी
May I please, Your lordship, on the last occasion, I directed to take fresh steps on the respondent by that state. So steps are being taken and we have filed an affidavit to that effect.
Are they sound?
My lord,
Are they sound? All are sound?
sir.
Mr. Datta, all are sound?
My lord, possibly, my lord, the service is complete. But so far I am concerned, my lord, I do not know my status. I wrote to them, but then there is no reply.
No, but we will, as far as IA is concerned, we will implement them as parties. Since 2017, the IA is pending for
Yes,
5 years.
exactly, your lordship.
IA we will dispose of today. Let them be parties. No harm is going to cause it.
Right, right.
Brother, what is that? Huh? Ah, yeah. Because they are all government officers.
Yes.
All learned comes to the party. So and so for so and so and so and so for so and so. All the parties are out. Considering the governments made in the application, the prayer prayed for implementing the authorities of the and different departments of the state of Nagaland is proper. The parties proposed to be joined are necessary and proper parties, and hence the application is allowed. Amendment to be carried out in the main matter forthwith. Note, and in main matter you file separate order. Notice to newly added parties returnable after 4 weeks. Next.
Public.
Oh, now let him sit. Complete the board.
May I please, your lordship, in this matter, service was awaited upon respondent number 13, your lordship.
Give it service.
We were
My lord, in my knowledge, my lord, the first petitioner, he has expired, my lord. He also needs to be substituted.
You are for the petitioner?
Yes, my lord.
Then please take instruction. Mr. Patak must be having some proof also.
Because he was our employee, my lord. The
natural.
service record, my lord, the death certificate is there.
Next. Take step 2 weeks. We defer for 2 weeks. Next.
Quickly.
This briefly is led by Mr. Senior Counsel, Mr. Baba. Today, this is some difficulty. Can it be adjourned for 2 weeks?
Next.
May I please? In this case, action taken report was posed.
Lordship, I have filed one affidavit, Lordship, where updated status has been mentioned, Lordship. And this is almost in the final stage, Lordship. Yes, Lordship. I filed it on 27 September, Lordship.
Page 137.
By the respondent, additional affidavit by the respondent number 9, Lordship.
But when is it likely to be complete?
Yes, Lordship, but this is not, but almost in the final stage, Lordship.
What is in the final stage?
Investigation.
When will it be over? We want the report.
Lordship.
We are deferring it by a week. Tell us next week how much time you want so that we can pass appropriate direction.
Lordship, 4 weeks time, Lordship, and accordingly I'll compare.
You first, we are keeping it next week. You tell us the time.
Lordship,
We don't want to
Lordship.
adjourn it after 4 weeks. again.
Lordship.
At the request of Ms. Bhattacharya ji. Next week.
Most of the.
Come next week.
Most of the.
Wait, next week means not Friday. Week thereafter. So you place it on 9th or 10th of November. Next.
This case relates to the obstruction of the underground water, my lord, for the want of the rule, my lord. They could not have taken action, my lord.
Lordship, the requirement of the act was that the rules have to be placed before the assembly, and they were placed, your lordship, on 12th last month, your lordship. Rules have now been notified, and the process of constituting the authority is already underway. So, your lordship, perhaps the prayers made in the petition are satisfied, your lord. Because the authority is otherwise empowered to take care of all the prayers made in the other prayers made in the PIL.
My lord, they have to implement it.
Code of below.
You place it on record.
Very well. I'll place it on it.
You place it on record. We can get only on. Patak 31st.
Very well.
Next.
May I please, Lordship, in this said case, the respondents have filed affidavit. So if my lord may kindly give us some time so that we can file this.
15th of November. 21st of November.
Obliged.
Next.
This is a lordship. Lordship on last occasion has called for the LCR, my lord.
LCR have been received.
Yes, my lord. Matter may kindly be fixed for admission, my lord.
Would you like to go for mediation proceeding?
Mediation, my lord, I have already informed informed the appellant, my lord, because he has some cardiac problem, my lord, and he's advised for medical death, my lord. That is why he has sought some advice, my lord, whether he can travel to Gauhati for mediation, my lord.
We can even refer it to Silchar mediation center.
My lord, he is the appellant is from my lord, Tinsukia district, and respondent is from Karimganj district, my lord.
No, respondent has some difficulty.
Appellant, my lord, yes, some
Appellant.
cardiac problem, my lord.
Appellant.
Appellant, my
Then we can ask the Tinsukia mediation center to handle it.
lord. So,
You may not have
lordship, if your lordship may pardon me 1 week time, my lord, to seek instructions about this mediation, my lord, I will place it by next week, my lord. I place the same on
At the
record, my lord.
request of so and so 2nd of November.
Okay.
We would like to explore the possibility of mediation.
Definitely, my lord.
Next.
May I please, your lordship. My lord, with regards to respondent number 9 to 12 service report associated note, and respondent number 13, 14 already presented.
Image service for respond number 9.
9 to 12.
9 to 12.
Obliged.
Adjourn to 10th of November. Next.
I am appearing for respond number 13 and 14, lordship.
You file your appearance.
Yes.
Next. You are Mr. Chaudhary. You are Mr. Chaudhary?
A few word by lordship. Chaudhary is my senior, lordship.
Okay. Next.
Appearing for the respondents, my lord.
Yes.
I'm appearing for the respondents, my lord. The appeal is not yet admitted, my lord. Notice was issued. Service is completed. I'm appearing for all the respondents.
Why do you want us to admit the appeal?
No, not just admit the appeal, my lord. Lordship was pleased to issue notice, my lord. The disciplinary proceeding, my lord. Removed from service. Not a single judge has dismissed the reputation.
Mr. Counsel, when we are telling you that why do you insist for admission of the appeal, you should presume that we know something about the matter. It's a question of manipulation of the original record. So why do you insist for technicalities of admission? When will you argue the matter?
My lord, any date, my lord.
Here you are relying upon some Supreme Court judgment?
Yes, ma'am.
You can go through one judgment, 2022 Supreme Court cases 563, both of you.
Yes, my lord.
Pick some date in diary. Hello, next. Done. Meta bill. Private service. Storage service. Press notice to unsolved respondent. Returnable after 4 weeks. You learn counsel for the appellant to take steps immediately. To be served additionally by registered post AD. Next. You inform Mr. S. Nath about it. Inform the learned advocate for the appellant. He is not here. Next.
May it please, Lord. Lord, this is an application for continuation of delay in a writ appeal. Notice was ordered on 30th of September 22. We had taken steps on 1st of October.
All are served, Mr. Ganpati? All are served?
Lords, I am not aware of respondent number 1. We inquired from the registry. A memo was issued on 10th of October is what we were informed. My request to your Lordship, Lords, if the registry can check, because this is by registered post, it can always be tracked. There will be a consignment number and the status of service can be verified by the registry.
There's
a delay of 179 days.
Where have you mentioned in your memo or in the prayer clause?
It is mentioned.
It should be in prayer.
I'm sorry, the prayer does not seem to mention the number of days delay, but it is there at
That we have noticed. Therefore, we are asking you. It has to be in the prayer.
I understand. But para 10, it is mentioned.
That we have seen, Mr. Ganpati.
Yes, Manoj. I agree. It must have been stated in the prayer.
It appears that you have given up the habit of looking at the draft now, as you have become senior now.
Not at all. Not at all.
Huh? So there is an additional dispute and effect longer. There is an endorsement about the service to none. Additional affidavit on Santo character expenses and fees. Issue notice registered post ID has been issued and can you get the report, because this is of 10th of it comes from outside. Mr. Ganpati, you wait. We'll inquire from the.
I'm grateful.
Yes, learned advocate.
This matter relates to tender issue, Lordship.
But now it has lived its life.
That is in my humble submission, incorrect submission. Because if you look
can we extend the time limit of the
no,
NIT?
it is not that issue is not an issue.
No, can we extend the time limit of NIT?
No, in fact, I was a valid tenderer. I should get the.
We have not to examine that now.
Lordship.
Now the time of that tender, even if you were a valid tenderer.
No, that cause of action has. Lordship.
Even if we consider that you are a valid tenderer, the period is over.
No, that is what I am submitting, Lordship. The period has not started till date. The period will start from the date of agreement.
That you can't get indirect extension like this.
No, I'm not running it.
Then we'll hear you on merit.
Lordship, I'm not running it. I was a valid tender. I should get the tender.
Mr. Saikia,
somebody else is.
It was up to 21. A particular date.
No, that is what is being misled by before this honorable.
That is what Mr. Das tells us.
Yes, 2021.
No, Lordship.
It is period for two years.
2 years from the date of agreement. Where is the date of agreement?
Mr. Sakia, don't be so technical. Otherwise, if we are technical,
Lordship.
ultimately 226 is discretionary.
Lordship, Lordship.
Ah.
Let it be heard, Lordship. Whenever Lordship pleases.
So don't be technical. We know that. Because you are protected by the interim order, you want to continue.
Yes,
No,
that's what's
no.
happening.
Naturally, Mr. Sakia.
Absolutely on affidavit, I can say, we are not running it. I am a bidder only.
You are.
And they have offered a bid to a person who has been endorsed by the Honorable Chief Minister of Mizoram.
Who's running it now?
Who is running it?
Some third party.
No, third appellant. One of the appellant.
There are two writ appeals. I am the writ appeal whose bid was perfect, valid. I should have got it. They have given it to one person who does not have a valid license also.
No, we agree with you.
Lordship.
We entirely agree with you. Even if we agree.
Lordship.
You refer to the need work for particular period.
It was for 2 years from the date of agreement. That has not culminated. That has not started.
Maybe. See, you say that it's a valid acceptance.
Valid, they have accepted invalid tender.
Your at the most your case at the highest is that your offer is accepted by the.
Mine is accepted. There is also accepted, but
no. Therefore, state of Mizoram has accepted your proposal.
Lordship.
Then ultimately, if that then file suit for.
No, it is not like that, Lordship. My humble, let it be heard, Lordship. Let me place my facts. Then everything will get very clear.
My lord, but
Immediately
immediately academic, my lord, always it is, my lord, the appellant, kindly say 74, my lord. The agreement has been executed with the private respondent.
In a lighter vein, we can only say that when you appear against state of Assam, you will take the same contest.
Lordship, I would only want that Lordship may be pleased.
Because Mr. Saikia hardly gets opportunity to be here and argue.
My lord, both are the appellant. My lord, we have given to a private respondent. Let us say that is illegal. That has been interfered by the court and there is a stay order operating. And the person who is running it from last 2015 is continuing it, my lord. This is for a period of 2 years.
But we
and
can
my lord,
dispose it of without hearing. So we'll hear you. There's no difficulty.
well, let the interim order be vacated, my lord. Interim, there is an interim order.
Nothing will survive thereafter.
My lord, today is 2022, my lord.
No, that will require some hearing.
It will require hearing, Mr. Sar.
As good as making a final hearing.
No.
We can hear it on
21st. Slight appearance. We'll hear you.
Lordship.
On that day finally.
Lordship. I am highly, Lordship, I would like to file few documents, recent documents we would like
If
to
we are
place.
ready, we may fix it. Otherwise, we may not fix. We'll hear you on appeal now. It is pending since 2019.
Yes.
3 years have already passed.
I think 4th of November or 4th of November, 3rd of November, which is convenient.
Let it come on 9th of October or 9th of November.
Okay. Okay.
Lordship. Highly
Right.
authorized, Lord. Deeply authorized.
Tidy mail. But there's no other matter. Call for service reporting. How long will it take? That's what that sir, if it likely to take more time, we may retire and then come. Then we'll get the chamber. If it is coming within, then we'll retire and then tell us. You inform that council, Ganpati or the you be here. We have called for the.
Very well. I'll wait.